designated as domestic terrorist organizations?
I'm not going to commit to anything to you because you won't let me answer questions.
Okay, well then we do understand that your current position is that you have a secret list of people or groups that you are accusing of domestic terrorism, but you won't share it with Congress. And I'd remind you that when the U.S. government designates an entity as a foreign terrorist organization, it must report that to Congress and to the entity, because the government can make a mistake and the entity has the opportunity to contest it. So your position seems to be that if you falsely designate an American or an American organization as a terrorist group, there's nothing they can do about it. I think we get it. You don't want to answer the question.
No, you don't get anything regarding public safety.
Thank you.
Nothing.
There is a binder, a literal binder, sitting on the table of the Attorney General of the United States. And inside that binder, there is a document that should not exist. Not a draft, not a briefing note, not a policy memo, a surveillance file. A printed record of the specific search terms used by a sitting member of the United States Congress while she was performing her constitutional duty of oversight. The Department of Justice did not gather this information to protect the public. They gathered it to use against the person asking questions. Here, play this clip.
The president's memo broadly and vaguely links violent conduct to ideologies, and it targeted specifically anti-American, anti-Christian, and anti-capitalist beliefs, as well as, quote, hostility to so-called traditional American views on family, religion, and morality, end quote. President Trump has repeatedly and openly, however falsely, tried to brand his political opponents with these sentiments listed in his memo. But as you know, as a lawyer, holding beliefs that the White House disagrees with is not a crime.
And the Attorney General brought it to the hearing. In a binder, labeled by those who saw it, a burn book. That is where this story begins. Not with a theory, not with a suspicion, with a photograph. On February 11, 2026, Attorney General Pam Bondi appeared before the House Judiciary Committee. She arrived prepared. She arrived with documents. And somewhere in the middle of that hearing, a camera captured a frame that the Department of Justice did not intend for anyone to see. A page inside the binder. A page with a header that read, Jayapal Pramila Search History. That photograph changed everything that followed. Because that photograph was not ambiguous. It did not require interpretation. It did not invite debate. It was a document produced by the United States Department of Justice, bearing the name of a sitting member of Congress, cataloging what she had searched for on a government computer while reviewing files related to one of the most significant criminal investigations in modern American history, the Jeffrey Epstein files. Here, play this clip.
So, Ms. Bondi, Section 3 of that memo directed you, as Attorney General, to submit to the President and Stephen Miller a list of groups or entities whose members are engaged in acts that meet the definition of domestic terrorism. And then on December 4th, you directed the FBI to work with a variety of law enforcement entities to compile a list of groups and entities engaged in such acts.
2 days after that photograph surfaced, a letter was sent to the Attorney General. It was signed by 3 ranking members of the House of Representatives, Jamie Raskin of the Judiciary Committee, Robert Garcia of the Oversight Committee, and Pramila Jayapal herself, the woman whose search history was in the binder. The letter did not ask questions. It made statements, confirmed facts, and it laid out a timeline that constitutes what legal professionals would call a forensic record of intent. Here's that timeline. Representative Jayapal reviewed the Epstein files on a Tuesday morning. Roughly 23 hours later, she was sitting in a congressional hearing room. In those 23 hours, the Department of Justice did not process evidence for prosecution. They did not identify additional victims. They did not pursue a single co-conspirator. What they did was access the logs of her review session, determine which terms she had searched, print that information, and place it inside a binder for the Attorney General to carry into the room where Jayapal would be asking questions. The letter confirmed that Representative Jayapal reviewed the search history document and verified its accuracy. She recognized her own searches. They were real. Here, play this clip.
By January 3rd, 2026, and to update that report every 30 days thereafter. So can we assume that you or persons under your direction at the Department of Justice have prepared that list of groups or entities who are designated as domestic terrorist organizations? And I just remind you, that's a yes or no question. Did you
Well,
prepare
I'm not
the
going to
list?
answer it yes or no, but what I will say is I know Antifa is part of that.
Okay.
I will talk to you about that.
This is not a leak. This is not a whistleblower's claim that can be disputed or delayed in litigation. This is a document the Attorney General of the United States carried into a congressional hearing room with her own hands. The evidence was already in the room. It just took a photograph to make it visible. At that same hearing, Attorney General Bondi made a statement under oath. She was being questioned by Representative Mary Gay Scanlon about the creation of a secret list of domestic terrorist organizations, a list that had reportedly been compiled to target political opponents. In response to questions about her department's conduct and its legal obligations, Bondi said, "We will comply with the law in all matters." Here, play this clip.
Will you commit to providing this committee with any list of organizations that you have recommended be designated as domestic terrorist organizations?
We will comply with the law in all matters.
She said those words in that room while the burn book was on the table. She is the highest-ranking law enforcement officer in the country. She holds the full institutional weight of the Department of Justice when she speaks. When she says we will comply with the law in all matters, she is not expressing an aspiration. She is making a legal assertion. She is telling Congress, under oath, that the executive branch is operating within constitutional limits. The burn book is the refutation of that assertion, not an argument against it, a physical refutation. A document proving that at the moment those words were spoken, her department was actively conducting surveillance on the legislative branch without knowledge or consent, for the purpose of preparing political counterattacks against the members conducting oversight. That is not compliance with the law. That is the opposite of compliance with the law. And she knew it, because she brought the evidence with her. But the burn book is only the most visible piece of a much larger pattern. The hearing itself generated a second document produced by House Judiciary Committee Democrats, cataloging 15 specific questions that the Attorney General refused to answer. Not 15 questions she answered poorly. Not 15 questions she deflected artfully. 15 questions she declined to answer at all. And the refusals are as revealing as the burn book because silence in a legal context is not neutral. Silence is information. She was asked how many of Epstein's co-conspirators her department had indicted. The answer is 0. She did not say 0. She did not say the number is under review, or that the question implicates ongoing investigations, or that she would follow up in writing. She said nothing, because to say 0 out loud, in that room, in front of cameras, is to admit that the Department of Justice has had access to one of the most extensive documented sex trafficking networks in modern history and has not used that access to charge a single additional person. She was asked whether she would create a joint task force to give state prosecutors around the country access to the department's evidence so they could pursue the cases the federal government refuses to bring. She did not answer, because the answer is no. And to say no is to explain why no. And there is no explanation for no that survives contact with the public. She was asked why the department has declined to investigate Prince Andrew, who appears in photographs contained within the Epstein files. She did not answer. She was asked whether she has any knowledge of President Trump's presence at parties involving underage girls. She did not answer. She was asked who at the department authorized the transfer of Ghislaine Maxwell. She did not name that person. She was asked whether the department would consider recommending a pardon for Maxwell. She did not rule it out. She was asked whether 500 department attorneys somehow failed to redact the names, identities, and sensitive photographs of dozens of survivors. She did not explain how that happened. She was asked whether prosecutors have an obligation to protect the identities of sexual assault victims. She declined to answer a question with a universally accepted answer. 15 questions, not one answered. That is the second piece of evidence. And together with the burn book, it forms a complete picture. The Department of Justice is protecting the people in the files and monitoring the people trying to examine them. This is the mechanism of the operation. To understand it fully, you have to understand how members of Congress are permitted to review these files. They are not given copies. They are not allowed to take notes freely. They are required to travel to a Department of Justice annex. They must sit at one of 4 government-owned computers. They must use a software system that congressional staff have described as clunky and convoluted. Department staffers watch over their shoulders as they read. The letter from the ranking members estimated that at the pace the current system permits, Checking the redactions on 3 million pages would take more than 7 years. 7 years for files that concern crimes committed against children. 7 years of controlled, monitored, restricted access, while the department tracks every search term entered on those 4 computers. This is not bureaucratic inefficiency. The infrastructure is too specific, too deliberate, and too complete for inefficiency to explain it. Control the room, control the computers, control the software, control the pace, and log everything the legislators look at so you know exactly what they know before they ask you about it in public. That is the operation. And the burn book is the proof that the operation exists. What is the strongest defense available to the Attorney General? She offered it herself at the hearing. Her defense is that she was not permitted to speak, that the members of Congress interrupted her, that the rigorous and time-limited questioning format prevented her from being transparent. She said, "I am not going to commit to anything to you because you will not let me answer questions." That defense deserves serious examination before it is discarded. And it does not survive serious examination. The questions she refused to answer were not complicated. How many co-conspirators have been indicted is a number, a single number. She did not need 5 minutes of uninterrupted time to say 0. She could have said it in the second before the next interruption. She did not. She spoke about Antifa. She deflected to procedural complaints. She filled the available time with everything except the information requested. The defense of procedural unfairness collapses entirely when measured against the burn book. A witness who intends to be transparent does not spend the 23 hours before a hearing compiling the opposition's research into a surveillance dossier. You bring a slander folder to a hearing when your strategy is not to answer, but to attack. The burn book is the proof of premeditation. She did not arrive at that hearing planning to comply. She arrived planning to counter. The law on this question is not ambiguous. The letter from the ranking member cites the speech or debate clause of the United States Constitution, Article 1, Section 6. The clause holds that members of Congress shall not be questioned in any other place for acts performed in their legislative capacity. The Supreme Court, in Eastland v. United States Servicemen's Fund, affirmed that this protection bars the executive branch from actions constituting distraction or disruption to a member's legislative role. In United States v. Rayburn House Office Building, the court specifically held that a legislator's review of outside documents is a protected part of the legislative process, and that indications as to what Congress is looking at provide clues as to what Congress is doing. What the Department of Justice did is precisely what that case law prohibits. By tracking search terms, they obtained clues about what Congress was investigating. They pierced the veil of legislative deliberation. They used a surveillance mechanism to monitor the thought process of the oversight branch. The letter states it plainly. This surveillance of members as we perform our constitutional oversight duties, done without our knowledge or consent, is a blatant violation of the separation of powers. The separation of powers is not a procedural technicality. It is the architecture of the republic. The legislative branch exists to check the executive. If the executive can surveil the legislative branch during the exercise of its oversight function, the check is gone. Not weakened, gone. The branch with the investigative apparatus, the lawyers, the federal agents, and the authority to prosecute is watching the branch whose only tool is the power to ask questions and demand answers. If asking questions generates a surveillance file, the power to ask questions has been neutralized. The Attorney General of the United States is a lawyer. She knows Eastland. She knows Rayburn. She knows the speech or debate clause by name. She knew what she was doing when her department logged the search terms. She knew what she was doing when she put the document in the binder. She brought it to the hearing anyway. The Republican Speaker of the House, Mike Johnson, was asked about the tracking of congressional search histories. He said, "I do not think it is appropriate for anybody to be tracking that." He added that he would echo that to anybody involved in the DOJ. That is the leader of the Speaker's own party, publicly rebuking the conduct of the Republican Attorney General. When that happens, the Attorney General has lost the shelter of partisan cover. She is exposed on both sides. The demands in the letter are specific and time-bound. The ranking members demanded that the department immediately cease tracking members' review of the Epstein files. They demanded a meeting to develop a new review protocol. They demanded written answers by Friday, February 20, 2026. They demanded a complete accounting. Every member whose searches were tracked, how long the data was retained, what the data was used for, who authorized the collection, and how many staff were assigned to monitor congressional activity. Those demands have a deadline, Deadlines in congressional correspondence are not arbitrary. They mark the point at which inaction becomes a decision. If the department does not comply, does not respond, does not set a meeting date, the procedural path forward has a name: criminal contempt of Congress. And contempt is not the ceiling of the available consequences. A documented violation of the speech or debate clause, conducted systematically with advanced preparation for the purpose of monitoring and countering legislative oversight, is the kind of conduct that has historically supported impeachment proceedings. The burn book is no longer a secret weapon. It is the evidence. The photograph made it public. The letter made it official. The deadline made it urgent. The Attorney General came to that hearing planning to control the information. She left having lost control of it entirely. The search history document was supposed to stay in the binder. The binder was supposed to stay in the room. The room was supposed to contain what Congress knew. None of that held, because someone took a photograph. And now the questions are written. The deadline is set. The law is cited. The search history is confirmed. The consequences named. What happens next will not be determined by rhetoric. It will be determined by whether the Attorney General of the United States answers the letter by Friday or whether she does not. One of those outcomes confirms the rule of law. The other confirms what the burn book already suggests. Before we close, one quick clarification. Everything presented in this script is drawn from publicly available sources: congressional correspondence, hearing transcripts, and documented public statements from elected officials and public figures. This is analysis and narration, not a call to action of any kind. Reasonable people reviewing the same public record may reach different interpretations, and that kind of serious, evidence-based disagreement is exactly what a functioning democracy requires. If you found this examination useful, or if you have a different reading of the evidence, the comments are open and the conversation is welcome. Subscribe if you want to follow where this goes next. The deadline is Friday.